Hi, I'm Ashley from Anglo Siam Legal. Today we'll be talking about trademark. Today we'll be discussing one of the most common issues in trademark registration, which is when the logo or word we wish to register lacks distinctiveness. And the issue arises when a mark is considered too generic or descriptive, and therefore unable to clearly distinguish the goods or services of one business from those others. Now, turning to the solution, one way to address the issue is through what is known as waiver of exclusive rights, or more commonly is a disclaimer. So this approach allows the applicant to proceed with registration while limiting exclusive rights over certain non-distinctive elements of the mark. So initially, the fundamental principle of the trademark law as a form of regulated intellectual property is to protect the identity and distinctiveness of goods and services belong to a juristic person. It ensures that trademark owners are safeguarded from dishonest or unauthorized use by others. However, it is important to understand that the law does not permit any party to monopolize the use of a single word that constitutes only part of a trademark. So in practice, elements of a trademark that are descriptive or generic in nature are usually subject to what is known as disclaimer. This means that while the trademark owner remains exclusive rights over the mark as a whole, they cannot claim exclusive rights over those generic or descriptive components. For example, in a registrations order, the term cafe was defined as referring to a small restaurant, coffee shop, cafeteria, nightclub, or self-service dining place. When used in relation to the relevant goods or services, the word merely describes their nature or characteristics. So as a result, the applicant was required to enter a disclaimer for the word cafe. The rationale behind this requirement is that cafe is a common term that must remain available for public use. So trademark law aims to ensure that such general term can still be freely used by others in trade. Without a disclaimer, the applicant could unfairly gain exclusive rights over a word that should remain in public domain. So finally, it is important to note that a disclaimer does not require any modification to the trademark itself. The disclaimed word can still appear in the mark exactly as filed. The disclaimer simply limits the scope of exclusive rights. And if anyone is looking for legal consultation or any kind of legal services, please contact Anglo Siam Legal. Thank you.